So, imagine you're a plaintiff in this really high-stakes lawsuit. You know, you've spent weeks drafting the perfect complaint, right?
Oh, yeah. And you
Right.
paid all those hefty filing fees.
Exactly. And, for an absolute fact, the defendant has read your documents. I mean, you know this because they are literally currently complaining about your lawsuit on Twitter.
Mm-hmm. Quoting your allegations word for word.
Right, word for word. But then, like, a month later, the judge just throws your entire case in the trash. And why? Because your process server handed the paperwork to the defendant's visiting best friend instead of their actual roommate.
It is honestly one of the most frustrating scenarios a practitioner can face. And it's a super classic scenario you're going to encounter when you're tackling the multi-state bar examination.
Yeah.
You really have to realize that the courts operate on just a completely different frequency when it comes to formal legal notice. Common sense, doesn't always apply here.
Well, welcome to today's deep dive. Your mission today is decoding the notoriously hyper-technical traps of notice and service of process. We really want you to walk into the MBE and navigate these questions without, second-guessing yourself.
Right, because that second guessing will kill your time.
Exactly. So to do that, we need to completely reframe how you think about the rules. Think of civil procedure like trying to get a VIP into a highly secure, restricted building.
I like that.
You aren't just dealing with one security checkpoint, right? You're dealing with two completely separate systems.
Yeah.
First, you have the background check. That is layer one, the constitutional due process requirement.
Mm-hmm.
And then you have the physical security badge to actually open the doors. And that is layer two, the federal rule of civil procedure 4.
That framing is just crucial because, passing the background check doesn't magically open the doors for you.
Right.
If you pass the constitutional background check, but you don't swipe your physical badge correctly under Rule 4, security is still going to throw you out.
Yeah, you're still out on the street.
Exactly. Mastering the distinction between these two layers and really understanding why courts treat them so differently is the ultimate key to avoiding the traps set by the bar examiners.
Because if you just memorize a laundry list of service rules.
Oh, you'll fail. Yeah, without understanding the philosophy underneath them, the exam will absolutely trip you up.
Okay, so let's start with that background check. Layer one, the Constitution. We are talking about the Mullane standard here.
Right, Mullane. The Supreme Court laid down this fundamental baseline for due process.
And they said that notice must be, quote, reasonably calculated under all the circumstances to apprise interested parties of the action and give them an opportunity to object.
Right. Reasonably calculated is really the center of gravity here.
Yeah, the emphasis seems entirely on the plaintiff's effort, right? Not the actual result.
Exactly. The Constitution does not demand perfect, guaranteed notice. It just demands a method that a person who actually wants to inform the other party would naturally use.
I always think about this, like sending out wedding invitations.
Oh, that's a great way to look at it.
Right. Like if I'm getting married and I drop your invitation in the mail sent to your correct, known home address, I've done my part reasonably.
Mm-hmm.
Even if you go on a month-long vacation and the mail piles up in your mailbox and you just leave that envelope unopened on your kitchen counter until, after the ceremony is over, I still invited you properly.
Yeah, you did everything right.
The Constitution doesn't require me to physically force you to open the envelope and read the venue details.
Yeah.
It just requires me to make a reasonable calculation that the mail will reach you.
The wedding analogy captures the spirit of Mullane perfectly, honestly. Yeah. The constitutional standard is highly practical.
Yeah.
You don't automatically lose your due process argument just because the defendant never actually read the papers. The focus is entirely on the moment you dispatched the notice. Was it reasonable then?
But wait, let's push that analogy a little further. What if that wedding invitation bounces back? Let's say it gets stamped return to sender and shows up in my mailbox a week later. Can a plaintiff just shrug their shoulders, march into court and say, well, I tried the reasonable thing, Your Honor, and ask for default judgment?
Well, the Supreme Court actually addressed that specific wrinkle in later case law.
Oh, did they?
Yeah.
Yeah.
If a plaintiff becomes aware that their chosen method has failed, seeing a returned, undelivered certified letter,
right,
and they have an obvious, available alternative way to reach the defendant, doing absolutely nothing more becomes constitutionally unreasonable.
Well, wow. Okay, so you can't just close your eyes, ignore the return mail, and pretend your reasonable calculation is still valid.
Exactly. You have to adapt based on what you learn.
So if I see the mail bounce, but I happen to have, your email address or I know where you work,
you have to take that extra step.
I can't just play dumb and rely on my first failed attempt.
Right. The court asks, in light of what the plaintiff knew or reasonably could have known after the failure, was this method likely to inform the party?
That makes sense.
And this constant requirement to be practical, it brings us to a massive, heavily tested MBE trap regarding publication notice.
Publication. Taking out an ad in a newspaper to announce to the world that you're suing someone.
Yeah.
It feels very like old-fashioned, like town crier territory.
It is super old-fashioned, but it still has a very specific utility in the law.
Really? Like when?
Well, if you're dealing with missing parties or unknown beneficiaries of a trust, or maybe a massive group of claimants whose identities are just simply impossible to track down.
Oh, I see.
In those cases, publication might literally be your only option. Under those very specific circumstances, an ad in the newspaper is constitutionally adequate because it represents the absolute best you can reasonably do.
But I'm guessing the bar examiners take that concept and stretch it to trap you.
Oh, absolutely. They love this. Publication notice is almost always constitutionally inadequate for a known defendant with a known address.
Right, because it's a total fiction in the modern world. I mean, nobody wakes up, pours their morning cup of coffee, and leisurely flips to the legal classifieds at the back of the local paper to see if they've been sued today.
Nobody does that. No.
If you know where I live, you need to send it to me directly. Putting an ad in the paper is not reasonably calculated to reach me if my home address is sitting right there in your case file.
And the courts look right through that fiction. Direct notice is constitutionally required when you know who the defendants are and where they reside.
Okay, got it.
So that's layer one. Did you satisfy the constitutional baseline? Did you make a reasonably calculated effort?
But surviving the Constitution only gets you past the background check.
Precisely.
Which brings us back to that Twitter scenario I mentioned at the start.
Oh, yeah.
So if the Constitution just requires a reasonable attempt to inform the defendant, what happens when the defendant finds out about the lawsuit through a completely informal, non-official channel?
Right, the actual notice trap.
Let's say the plaintiff botches the paperwork entirely. They don't even try to do it right. But the defendant reads about the lawsuit on a legal blog, or, I don't know, their friend texts them a screenshot of the filing. The defendant now has actual notice. They know they are being sued. Why wouldn't that satisfy the requirements?
The examiners will paint this exact picture for you. They'll craft a fact pattern where the defendant is fully aware of the lawsuit, maybe even holding a press conference about it.
Yeah, so it feels like they know.
Right. You will feel a strong temptation to conclude, well, the underlying goal of notice was achieved. They know about it, so the lawsuit can proceed.
But it can't, can it?
No. Actual notice does not automatically cure defective service.
Because we have reached layer 2, the Federal Rule of Civil Procedure 4, the physical security badge.
Exactly. A defendant reading about a lawsuit online does not excuse the plaintiff from following the strict, formal mechanics laid out in Rule 4.
Wow.
The judicial system requires standardized, verifiable boundaries. The courts need objective proof that the state's coercive power has been formally invoked against a citizen. Actual knowledge floating around in the ether just doesn't equal valid service.
Okay, so let's break down these formal mechanics. What are we actually handing them? We aren't just like passing them a sticky note that says, see you in court on Tuesday.
No, definitely not. There is a very strict anatomy to a valid summons.
Right.
A valid summons is a highly specific formal document. It must name the court and the parties involved.
Makes sense.
It must be directed specifically to the defendant. It has to clearly state the name and address of the plaintiff's attorney or the plaintiff themselves if they're proceeding unrepresented.
And it also needs to give them the countdown clock, right? Letting them know their response deadline.
Yes. The summons must state the precise time within which the defendant must appear and defend. And crucially, it must contain a stark warning.
A warning.
Yeah, a statement that failure to appear will result in a default judgment against them for the relief demanded in the complaint.
So basically, show up or you lose.
Exactly. And finally, to make it an official state document rather than just a letter from an angry neighbor, it must be signed by the clerk and bear the court's official seal.
And if you miss any of those?
Missing any of those elements means you have fundamentally defective papers.
Okay, let's assume we have a perfectly drafted summons, complete with the clerk's signature, the court seal, and the default warning.
Okay, perfect papers.
Now, who gets to be the messenger? Like, if I'm the plaintiff and I know exactly where the defendant hangs out, can I just march over there and shove the papers into their hands to save some money?
Rule 4 strictly forbids that.
Oh, really?
Yeah. The person serving the papers must meet two non-negotiable criteria. They must be at least 18 years old, and they must be a non-party to the litigation. The plaintiff absolutely cannot serve their own papers.
I mean, that feels like a crucial safety valve, honestly. You want to avoid a he said, she said fist fight on the front porch between the two people who are already angry enough to be in a lawsuit.
Exactly. A neutral, adult third party takes the heat out of the physical exchange.
And this neutral messenger is on a strict timer, aren't they?
They are. The clock is ticking the moment the complaint is filed. Under Rule 4 meter, the delivery generally must be completed within 90 days.
90 days. And if they miss it?
If the plaintiff misses that 90-day window, the court must dismiss the action without prejudice or order that service be made within a specified extended time.
Now, without prejudice means you can refile the lawsuit, right? But if the statute of limitations happen to expire during those 90 days...
You are out of luck entirely. Your case is dead because you couldn't beat the clock.
Oh, wow. That is the nightmare scenario.
It really is. Now, if the plaintiff shows good cause for the failure, maybe the defendant was actively dodging the process server, jumping out of back windows to avoid them.
Right, pulling a Ferris Bueller.
Exactly. Then the court is required to extend the time for service. But relying on the court's mercy to find good cause is a really dangerous game. You always want to beat that 90-day deadline.
Okay, so let's put these pieces together. We have a perfectly valid summons. It's being carried by a non-party adult, and we are on, let's say, day 15 of our 90-day clock.
Great. We are in great shape.
So how exactly do we drop these papers on the defendant without violating Rule 4?
Well, for an individual defendant located within the United States, Rule 4 provides a menu of options. First, you can always utilize the state law methods for service in the state where the federal court sits, or where the service is actually being made.
Okay.
Second, you can rely on personal delivery.
Which means literally walking up to the defendant and handing the documents to them.
Yes. Direct personal delivery is the gold standard. The server hands the summons and complaint directly to the individual. There is very little room to argue that personal delivery was insufficient.
But people are evasive. I mean, they have Ring cameras, they don't answer the door, they hide. So if I want to serve someone at their house, but they refuse to come to the door, what are my options? Could my server just hand the papers to the guy mowing the lawn?
No.
Or maybe a friend who I know is crashing on their couch for the weekend?
This brings us to a heavily tested nuance known as the dwelling trap.
The dwelling trap, okay.
Rule 4 allows the server to leave the papers at the defendant's dwelling or usual place of abode. But there are 3 strict prongs you must satisfy, and the examiners will test the boundaries of every single one.
Okay, what are they?
First, it must actually be their usual place of abode, their actual residence, not like a summer rental they stayed at 2 years ago.
Makes sense.
Second, the papers must be left with someone of suitable age and discretion. So a responsible teenager might work, but a 4-year-old certainly won't.
Right.
But the third prong is the ultimate kicker. That person of suitable age and discretion must reside there.
Wait, so the 35-year-old best friend who is just crashing on the couch for the weekend to attend a concert, they're of suitable age and discretion.
They fail the test.
Really?
They do not reside there. Leaving the papers with a visiting friend is legally defective service under the federal rules, even if that friend is a responsible adult who promises to hand the documents over to the defendant as soon as they get home.
Wow. But if I leave it with their adult roommate?
That passes the test perfectly. They are of suitable age, they have discretion, and they live at the dwelling.
I guess that makes sense.
Yeah, the underlying logic here goes back to our discussion about human behavior. Someone who actually lives with a defendant, who shares a lease or a mortgage, is far more likely to ensure the defendant gets highly important legal documents than a transient visitor who might accidentally, pack the summons in their duffel bag and fly home.
Right. That makes total sense when you look at the human element. Now, what if the defendant isn't a human being, but a massive corporation? You can't exactly walk up to a corporate headquarters and hand a summons to the brick wall.
No. Serving entities requires targeting the correct personnel. For a corporation, partnership, or association, you can again utilize state law methods.
Right.
Or, under the federal rules, you can deliver the papers to an officer, a managing or general agent, or any other agent authorized by appointment or by law to receive service.
Which means walking into a massive retail chain and handing a federal lawsuit to a random 19-year-old cashier working the register probably isn't going to cut it.
Unless a specific state law allows it, no, it won't. You need someone whose role in the company guarantees that the corporate hierarchy is formally put on notice.
The courts want to ensure the documents actually reach the decision makers.
Exactly. And just to touch briefly on a few special defendants, if you are serving a minor or an incompetent person, the federal rules differ entirely.
Refer to what?
You generally have to look to the specific state law methods to ensure those vulnerable individuals are protected.
Oh, gotcha. And what if the defendant is located in another country entirely? Do you send a local process server on an international flight?
That would be expensive. No. Serving foreign defendants involves highly specialized rules, most notably international agreements, like the Hague Service Convention.
Right, the Hague.
If a treaty applies between the U.S. and that country, you are bound by its procedures. And a vital note for the MBE, that strict 90-day clock we discussed under Rule 4 Maters.
Yeah.
It does not apply in the same strict way to service in a foreign country, largely because international service involves foreign ministries and translations, which, can take many months to navigate.
Okay, so with all these strict delivery rules, dwelling traps, visiting friends, and ticking clocks, this all sounds like an exhausting, expensive logistical nightmare.
It can be.
Isn't there a way for a plaintiff to bypass this entire circus?
There is. There is a remarkably efficient bypass mechanism designed specifically to save everyone time and money.
Oh, thank goodness.
The plaintiff can simply ask the defendant to voluntarily waive formal service under Rule 4D.
Okay, so Rule 4D uses a brilliant carrot-and-stick approach to encourage cooperation, right?
Miss Viss.
The plaintiff mans a notice of the lawsuit and a waiver request to the defendant. Now, you might wonder why a defendant would ever agree to sign a document helping the person suing them.
Right. Why help the enemy?
Exactly. The carrot is time. Normally, a defendant has a very short 21-day window to answer a complaint. But if a U.S.-based defendant signs that waiver of service, they are rewarded with 60 days to answer.
And if they're outside the U.S., they get 90 days.
Right.
That extra time is incredibly valuable. I mean, it gives the defendant breathing room to hire local counsel, investigate the claims, and draft a comprehensive motion to dismiss.
And then there's the stick.
This stick.
If a defendant located in the United States stubbornly refuses to sign the waiver without good cause, the plaintiff is forced to go hire that process server and jump through all the traditional hoops.
Yep.
But the court will penalize the uncooperative defendant by forcing them to pay the expenses incurred in making that formal service.
You get extra time if you play nice, and you get a bill if you are difficult.
It's a great system.
It really is.
Yeah.
But wait, I have to challenge this from a strategic perspective.
Go for it.
If a defendant signs an official court form acknowledging the lawsuit and sends it back to the plaintiff, aren't they basically surrendering to the court's authority? Doesn't waiving service mean you are waiving your right to fight personal jurisdiction? Like, I signed your form, I guess I'm stuck litigating in this state now.
I am incredibly glad you brought that up, because you have just identified the single most dangerous trap on the entire MBE regarding this topic.
Oh, wow.
I cannot emphasize this enough to anyone listening. Waiver of service is not a waiver of personal jurisdiction or venue.
Let's unpack that. Why are they treated differently?
Because they address fundamentally different aspects of the court's authority. Personal jurisdiction, or PJ, asks a deep constitutional question. Does the court have the power to drag this specific defendant into this specific state? Do they have minimum contacts? Is it fair and substantial justice?
Service of process, on the other hand, just asks a procedural question about formal notice. Did you receive the envelope in the correct, legally prescribed manner?
Oh, so waiving the delivery mechanics doesn't magically create minimum contacts with a state you've never even visited.
Exactly. Signing a waiver of service simply says, I acknowledge receipt of these documents. You don't need to pay a private investigator to track me down at my house.
Right.
It absolutely does not say, I agree this court has the power to judge me. A defendant could sign a waiver of service, secure their 60 days to answer, and then use that exact 60-day window to draft a brilliant motion to dismiss for lack of personal jurisdiction.
Wow.
Waiving the messenger does not waive your right to fight the court's power over you.
That distinction is monumental for exam day. Okay, let's look at the alternative. The defendant doesn't waive service, the plaintiff tries to serve them physically, and the plaintiff messes up the formal delivery. How does the defendant actually fight back in court? We know they file a motion to dismiss, but when looking at Rule 12, there are two different defenses that sound almost identical. Rule 12b-4 and Rule 12b-5.
They look like twins, but they attack two completely different failures in the plaintiff's process. Rule 12b-4 is for insufficient process. This defense attacks the documents themselves.
So bad papers, like the plaintiff forgot to get the clerk's signature, or there's no court seal, or they completely misnamed the defendant on the actual summons.
Yes. 12b-4 means the physical documents are fundamentally flawed. Rule 12b-5, however, is for insufficient service of process. This defense attacks the delivery method.
Ah, bad delivery. So the papers are perfectly drafted, they have the gorgeous court seal and the clerk's signature, but the plaintiff's server handed them to that third. I'm on the couch.
Exactly. 12b-4 is the what, and 12b-5 is the how.
12b-4 is what? 12b-5 is how?
And practically speaking, 12b-5 is heavily litigated because of the statute of limitations.
Why is that?
Well, if the plaintiff makes a typo on the summons, a 12b-4 motion usually just results in the judge telling them to fix the typo. But if a 12b motion successfully argues that delivery was invalid and that 90-day clock we talked about has expired, the case might be dismissed entirely.
Ouch.
If the statute of limitations ran out while the plaintiff was fumbling the delivery, a 12b victory is a fatal blow to the lawsuit.
That makes so much sense when you frame it around the statute of limitations stakes. Now, regarding litigation strategy, there's a critical procedural rule governing these specific defenses, right? It's a strict use it or lose it situation.
Yeah, it is. Unlike subject matter jurisdiction, which asks if a federal court is even allowed to hear this type of case, and which can never be waived, even on the last day of trial.
Right.
These service objections under 12b and 12b-5 must be raised in the very first Rule 12 response the defendant files.
The very first one.
Whether their first move is a pre-answer motion to dismiss or the answer itself, those objections must be in there.
So if a defendant files a motion to dismiss for lack of personal jurisdiction, but forgets to include their complaint about the visiting friend receiving the papers,
they have waived the 12b-5 defense forever. The court will treat the defective service as if it were perfectly valid.
Use it or lose it. Man. So what does this all mean for you as you prepare for the exam? When you're staring at an MBE fact pattern filled with dates, roommates, mailings, and waivers, you really have to split your brain in two.
Absolutely.
First, did they meet the constitutional baseline of Mullane? Was the attempt reasonably calculated?
Right.
If yes, put down the Constitution and pick up Rule 4. Did they follow the strict physical mechanics of the 90-day clock, the neutral server, and the dwelling rules? And finally, if they waived service, remember that they didn't waive jurisdiction. Keep those distinct buckets separate in your mind, and you won't fall for the trap.
Approaching the problem by separating the constitutional background check from the procedural security badge really allows you to isolate exactly where the examiners are trying to trick you.
It filters out all the muddy waters. But before we wrap up, I do want to leave you with a final forward-looking question to mull over.
Oh, I love these.
We've spent this whole time emphasizing that under the current version of Rule 4, actual informal notice doesn't cure bad service. Even if you have proof the defendant read the papers on Twitter, if you handed the physical copy to their visiting friend, it's defective.
Right, because the current federal rules demand a physical ritual.
But as we move deeper into an era of relentless digital communication, things are shifting, right?
Oh, totally.
Imagine a near-future scenario where a plaintiff can easily prove, cryptographically, that a defendant read a direct message containing the summons or, opened a secure PDF via digital read receipts, all while that exact same defendant is actively hopping fences to evade a physical process server in the real world.
Right.
At what point will the traditional federal rules of civil procedure be forced to adapt? When does a verifiable digital footprint become the ultimate undeniable proof of a reasonably calculated and legally valid delivery?
It highlights a fascinating tension between 20th century paper rules and 21st century digital reality. I mean, we are increasingly living in a world where physical location matters less than digital presence.
It's so true. But for now, the old physical rules stand firm, and you have to master them for the bar. But keep your eye on the horizon, because the definition of a reasonable delivery might just be a click away from changing forever. Until next time, keep digging deep.